Hmm. Well, I think we'll go ahead and get started. Want to thank everyone for coming today. This CLE, and I'm kind of serving as our MC. I'll be joining the conversation a little bit as well, but I'll be here to kind of keep us moving and also to help facilitate questions. So along the way, if you have questions, feel free to ask them in the chat. If we'll also a few times we might just open up the floor as well. But if you have questions along the way, go ahead and drop them in right away. And then that way, when there's a good time, I can ask the other presenters, we can bring up the questions. A couple of other administrative details. Don't forget, if you haven't yet registered for the CLE, please do so. There's a link in the chat I put a little bit earlier. And that's for a couple of reasons. One is, of course, for attorneys seeking CLE credit, we need to know your stuff so we can get you what you need for on the CLE side of things. But also, we do have some additional materials, and Anna Maria has some, but I also know Kathy Gilbert, she had sent me something yesterday that we didn't have time to put up on the website yet. So we have several things be coming afterwards. We also will send out an evaluation afterwards as well. So be sure and do that. And lastly, on the cost for attorneys who want CLE credit, it's $50. And I'll send an email after this to everyone, again, who's registered with information on that. For anyone who doesn't need CLE credits, then it's just donation only. Anything you can give would be appreciated. So without further ado, let me introduce our speakers for today. My name is James Branham. I'm a solo practice attorney out of Oklahoma City. Anna Maria, would you like to introduce yourself?
Sure, absolutely. Yes, Anna Maria Bondoc, she, her pronouns. I recently moved outside of Honolulu, Hawaii. Before that, Barstow, so the Route 66 connection. I work at a nonprofit called the Veterans Consortium, TVC, specifically in the Discharge Upgrade program. So wonderful to be here. Thanks for having me. Dan, would you like to go next?
Sure. Hi, I'm Dan Mayfield, he, him, if it makes a difference to you. The first 2 years I was a lawyer, maybe 3, I did nothing but discharge upgrade work. Since then, I've kept my fingers in it. But in any case, mostly I do criminal defense work, but it ties into this veteran stuff, as we'll talk about, because of Veterans Court. And also, if we're looking for materials, it's really the same. You look the same places. So we'll get into that.
Really notice longer, fuller lashes and more hair in my.
Just a reminder for everyone, if you have, be sure to mute your audio if you're not actively talking. Really appreciate it, so we don't have a lot of background issues. So our first thing we'll be talking about today, first question is, why is bad paper an issue? And kind of goes into the related issue of why we do this work. So who would like to start off the conversation?
Don't everybody speak at once. This is Dan. I'll start. I like doing this work because it really makes a change in people's lives. I see it as part of my anti-racist work, and I want to just bring up one statistic here. Most states have special veterans loans that they give, and you can't get those loans if you have bad paper. And here's an incredible example that, and typically of the Veterans Administration and the government, they like to keep statistics based on black and white. So it's kind of hard to get statistics for outside of that. But that for veterans, the difference between black and white ownership is 15%. In other words, it's still racist, but the difference is only 15% between black and white home ownership for veterans. For non-veterans, the difference is 30%. So for black veterans, that your chances of being a homeowner double. And they so just in terms of the importance of doing the work, to get a good discharge, increases your ability to be a homeowner, increases your ability, you get extra points on civil service tests. You obviously get access to the Veterans Administration. We'll talk more about that because bad discharge isn't definitively doesn't definitively mean you can't go to the VA, but makes it tougher. And that, so it just increases the quality of life for people across the board. So with that, I'll stop.
For myself, I got into this work on the discharge upgrade side because it was the natural component after, because most of my career had been on the trial side of things, in courts martial, administrative hearings, things like that. And it was clearer and clearer that many of my clients, the best deal we could get at a given moment might be another than honorable discharge. That might literally the best we can do. Obviously, though, that's not acceptable for my clients' long-term success in life. For many of them, they need those VA benefits. And so that was how I got into it. But over time, it also, one of the things I appreciate about learning about discharge upgrades, engaging with them some, is even on my clients who I do not do the discharge upgrade piece of it. In other words, many of my clients, I take them through trial or through their military discharge. I'm not necessarily working with them after that. But even in that case, it's very much informed how I practice on the pre-trial stage and or the pre-discharge stage. Because now, knowing what I know about discharge upgrades, I am now continually thinking about the record in a way that I had not before. And I really see now so much of what I do in seeking a discharge, for instance, or in defending someone in a court martial is often with an eye to what will the Discharge Review Board think of this? What evidence can I put on the record now that can be used later in other contexts? And so I would argue that even if you don't anticipate yourself doing this particular work, I think it's something you need to know about, because so much of the success at in a discharge upgrade situation often depends on what happened earlier and what records were preserved. So that's my main interest in it. Anna Maria?
Yes, I've long been wondering where it got in my head that discharge upgrade work could be a continuation of like anti-racism work. And I guess I must have heard Dan say it before, because I've certainly copied that, in my thinking, and tried to be more aware of how, systemic issues like that could be affecting, my clients that sure look like they have a similar fact pattern to somebody else, but, had, way more severe lifelong consequences in terms of the discharge they received. I'm a military spouse. I have a lot of personal experiences that I'm formerly a civilian. Somebody that's never served, and I think of this as a way that I can give back to folks that did sign up and put their life on the line. Right, our nation's heroes. Around this time of the year, fall, Veterans Day coming up, there's a lot of programming around veterans issues and veterans benefits and that sort of thing. And the clients that come to us are the folks that maybe don't identify as a veteran, right? They've been excluded from that community and that continued camaraderie because of the circumstances of their discharge. And if there's anything that we can do to review to perhaps correct something that was an unjust experience for them, I think that it's well worth our while. And hey, if benefits flow, even better.
Absolutely. Well, that brings us now into more the practical side of today, and we're going to touch more on the philosophy of this, why we do this. It'll come up again and again throughout this presentation. But we want to talk now about the practical side, and the first really range of issues is what I guess we would call issue spotting. How, when someone comes to us with, as for those of you who are attorneys, and I know we have a mix of attorneys and GI rights counselors, but really in either scenario, the first thing that many of us do is that we
lost you. James, you went silent.
Sorry, still nothing now, James. We'll
okay,
stand
can
by.
you hear me now?
Yeah, you're back. Mm-hmm.
Okay, so this is confusing. My phone, sorry, we're having all kinds of audio issues today. Okay, we're just gonna do it this way. Okay, can y'all? Maybe not.
No, you're fine. You're fine now.
Okay. Okay, can you hear me now? Okay. Uh, okay. Sorry, we're having the sound out if I'm not hearing it.
You're fine for me, James.
Okay. Yeah, I see what's going on. My Bluetooth thing is interrupting with the long story, but anyway, it'll work. Okay. Um, I lost my train of thought there. I'm so sorry.
No problem. Yeah, we were just moving on to sort of issue spotting, and I think the topic of if we're talking about discharge upgrade or records correction, what records are we looking at to correct, perhaps?
Mm-hmm. We also are often looking for how do we refer, what are the circumstances we refer to other agencies, other people in various appropriate situations. So what would be some of those scenarios where that someone comes to us, maybe they're thinking it's a discharge upgrade situation, but it might not be. What would one of those situations be?
Anna, this was yours.
No problem. Yeah, no problem. One situation may be if we alluded to earlier in our introductory comments. If the veteran's goal really is some kind of benefit from the Federal Department of Veterans Affairs, right? Applying for a discharge upgrade is not going to directly change access to VA benefits, right? So if you apply to the VA, they're the ones that will respond. But they actually have their own regulation and definition to apply when it comes to who they count as a veteran and has established basic eligibility for most of their benefits, right? So of course the big ones being either compensation or pension and healthcare at the VA medical centers. And so if a veteran comes to you and they're saying the VA denied me, the VA denied me, one thing to make sure that the veteran understands is that the VA's character of discharge process is separate from a discharge upgrade from their service branch. So it, you know, there are resources from an organization called Swords to Plowshares that are really helpful in helping folks understand the difference between a discharge upgrade and perhaps you could think of it as an alternative to a discharge upgrade if a VA benefit is the main goal. So consider, figuring out if the veteran has access to a VSO that's knowledgeable in VA character of discharge cases, or if they live in a state that has a legal clinic that might help with appeals. Because there are, also high rates of denial for VA character of discharge cases, but have a lot of similar impacts in terms of access to benefits. That might be what the veteran's really looking for.
In the old days, I used to get probably one person a month who would come into my office and say, I can't vote. And they were told this when they got out of the service, especially people who got a BCD or a DD. And that's just basically not true. There are only about 10 states left where felons can't vote. And so in terms of the kind of remedies that you're looking for here, I have one case now for a guy who is a sex registrant as a result of something that happened in the military. And of course, that's really a California question about was the military crime equivalent of a California crime, and not so much a military case, although obviously we're going to work on both parts of it.
For sure. That's such an important point. There's a lot of misinformation and because in the veterans community, word of mouth is such an important way to either make yourself known for good reasons or bad reasons, right? It's tough to fight back against some of those myths or prevailing things that people believe to be true regarding a discharge that's other than fully honorable. So yeah, another example I can give is related to the VA, again, misinterpreting its own regulations and programs. For a few years, the the HUD-VASH program and supportive services for veteran families. So programs that are aimed at trying to address the issue of homelessness among veterans. There was a lot of confusion over what type of discharge a veteran had to have before they would be eligible for a lot of those benefits. And those are, again, basic homelessness prevention services. So fully honorable was not required, right? Certainly general under honorable conditions would be fine. You don't need a discharge upgrade for that. You just need to get through to the gatekeeper that's preventing the veteran from getting those services. And again, most OTHs likely eligible for that, even though that was something that needed to be clarified. So it's a matter of really speaking with the veteran to understand what their goals are, what barriers they're facing, and whether correcting the military documentation is what needs to happen, or other advocacy with other agencies like the VA or state or local department.
By the way, we've had some interesting comments in the chats about dishonorable discharges, and so I thought we'd just touch on this really quickly. And actually, I think it wasn't in our original outline, but talking through just briefly what some of the remedies are depending on what kind of discharge a person has. Again, most of you are already going to know this, but as the discharges are honorable, general, OTH or other than honorable, BCD, bad conduct discharge, and then DD, dishonorable discharge. Those bottom, and then of course there's also uncharacterized separations, which I always tell my clients is kind of like dropping a class in college. They put a W on your transcript. It doesn't, you weren't there long enough to make an impression one way or another. So those top three discharges are administrative discharges. Dan's laughing.
I love it. I never thought about that.
It kind of is though.
I love it.
So those top three discharges are administrative discharges. They normally do not come from a court martial, but they come through some kind of administrative procedure. Sometimes, though, those can be if someone was court-martialed, particularly with a summary court-martial, often then there would be a discharge later, usually an OTH. So sometimes you could get a discharge after a court-martial, but it wouldn't be adjudged by the court. BCDs, bad conduct discharges, in most contexts are treated as federal misdemeanors, but we all need to warn our clients that this is also a factor of state law. States and the feds don't always define felonies the same way. Other countries will not define felonies the same way. And since the military doesn't in paper say this is a felony, this is a misdemeanor, it often you can argue a little bit to say, well, yes, this might have been a felony in a context that's not here. Generally, a dishonorable discharge is treated as a felony for all purposes. I know specifically on federal firearms law that a person with a dishonorable discharge is is in possession of a firearm, they've committed a federal crime, just as even if they were convicted of a felony in the civilian sector. That said, I will mention that no one gets a BCD or dishonorable discharge without a court-martial conviction. You can't get those bottom two. So there is the discharge itself, but it's really because of a court-martial. So Anna Maria, would you want to share us a little bit just of what difference it makes depending on which level of discharge a person has as far as the discharge upgrade possibilities?
Sure. Yeah, I'm not sure if you're trying to get me to talk about the difference between the two boards, James. But so as I mentioned earlier, each service branch has a board. Aside from Navy and Marine Corps, you go to the same board for that. And then there's a lower board and a higher board. So first, within 15 years of discharge, a veteran can apply to the Discharge Review Board for their branch, so the DRB. So they have some more limitations on their powers, but they can make some of the more important changes on a DD-214, for example. So your eyes, if you have some practice in reviewing DD-214s, your eyes tend immediately to sort of go to the bottom, right? Box 24 is where they have the character of discharge listed. And then 28 is where they have the narrative reason for separation listed as well. Separation code just matches the narrative reason, as well as the reenlistment code, RE code. So that's in a nutshell what the Discharge Review Board can review. So they can they can review applications for veterans who applied within the 15-year statute of limitations, and then also who didn't receive a discharge by sentence of a general court-martial. So if you have a veteran that had the most severe, type of court-martial, and they got sentenced to either BCD or fully dishonorable, they got to go to the higher board. That's the Board for Correction. So Board for Correction of either Naval or Military Records. So BCNR, being the higher board, has more power to change a military record based on an error or injustice. BCMR, BCNR is also where you'd go if you're trying to change a discharge from, say, a fully honorable discharge to a medical discharge or disability discharge. So it depending on what relief the veteran is looking for and how long it's been since they were discharged. Usually those are the issues that would guide you to figure out which board their application should be reviewed at.
One of the key things to me when looking at these boards is the powers of different boards. Okay, this is very confusing. Okay, sorry, I forget which. I so apologize for audio issue, sound issues today. My camera decided to break today, so. Anyway, though, one of the big issues I know for BCMR is often the choice between Discharge Review Board versus BCMR is what relief you can get in each venue. In the Discharge Review Board context, my understanding is you can really, the only thing you're able to get there is a change of the discharge characterization. Is there anything else that can be done through DRB?
Sure, yeah. The DRBs can also change the narrative reason for separation and the reenlistment code.
And the reenlistment code.
That's right.
Have you ever won a reenlistment code case, Anna Maria? I never have. I'm not sure how many of these cases I've done.
I won one, and it was a weird case. It was a case of mistaken identity where my client, basically in her unit, was a National Guard unit. She was the spitting image of another person in the unit, another female soldier. They were both of the same ethnicity. And the other soldier, and to use the military vernacular, was the proverbial shitbag soldier, who was not a good soldier, was problems. And unfortunately, my client got pinned with several of the things the other soldier did. And my client was found him, she wanted to retire. And so we went to DRB, and through that, we were able to change the reason for her discharge initially, and then also change the RE code. And so that was, but it was such an we were so lucky though, because we actually were able to find some documentary evidence that made it really clear it really was the case of mistaken identity.
For sure, yeah. For me, reenlistment code is usually not the primary relief that we're seeking. So I would say that if it's on a list of, three or four changes that we're trying to ask the board for, it's the most frequently denied relief. So they might split the baby a bit and, give us something on the characterization, maybe bump up for one from OTH to general. They might, give us what we ask for in terms of removing stigmatizing information from the narrative reason. But they might say, we don't think, we don't want to fully remove the barriers to rejoining the military. Even though that's not always the reason to remove that, RE2 or RE3 or 4 from a DA 214. Just the fact that it's on there raises questions, right? And so that mostly is the reason we recommend that you at least ask for a change, either at the DRB or the BCMR, BCNR. I brought it back, James. I brought it back. Differences between the boards. Yeah.
Let me suggest, because we're like half an hour in here, that we kind of move on to the building a case, and let me start with getting records and everybody else chime in so that we'll talk about, first thing you want to do is you want to get the military records. Now that there's a form for that, like there is for everything, that you want to fill out the DD 180, send it in. It's better if you have the veteran sign it. That you can get them without the veteran signing it, but it slows things down. You can apply online or through the mail. If you apply online, it's faster. Once you get those records, we'll talk about how to read them. But let's talk more about what records you want from the military, and then let's talk about what other records you want, depending on how you're going at the BCMR or the DRB.
Well, speaking of the issue of the records themselves, one thing is when you ask for the records, they will give the serviceman or the veteran the chance of asking for just the DD 214, or they can specify other kinds of records. And my encouragement is ask for everything, because you just never know what you're going to need. Also, you have to operate from the assumption that whatever is in the records, the board will see. So we need, if there's bad stuff in there, better to know about it, be ready to explain it away, rather than it being a doctor that the board finds out about and you're not even tracking with. I will also mention that ordering the records early is important. It takes quite a while to get records. It's better than it used to be, but Anna Maria, what's been your experience on how long records requests are taking these days?
Oh boy. I'll say the digital request at archives.gov, we've been asking veterans to give that a try. But if they're not successful, we're still going back to good old fashioned SF-180, like Daniel mentioned, getting that in and asking the board to send, asking archives or NPRC to send the complete OMPF. So during the pandemic, we're getting automatic notices that, if there were closures or staff reductions and that kind of thing. Some of those have cycled, have gone through, and it seems like they're working through their backlog still. So requests sent in from 2020 to now still are coming in. But for requests that we're sending anew, I think we're seeing like an 8-month turnaround. 8 to 12 months, just depending. What's frustrating with that amount of wait is when the NPRC does, the supposedly taxpayer, responsible, funding way of trying to reduce expenses, which is to send just the extract of the OMPF, not a page for page copy. So if we're waiting this whole time, we ask them, please don't send us an extract, and they still routinely do it. So something to be aware of. As soon as you get that, the cover letter that says, hey, we went ahead and sent your extract, you're welcome. Definitely fire back and say, no way, this is not good enough. Don't close this out. You have more work to do, because we really do need the complete file to see what arguments are possible or what is damaging there, like you pointed out.
One thing I do with prospective clients who call me, I even tell them before you can schedule an appointment with them. If I know it's about a discharge upgrade case, I will tell them whether our upcoming appointment, right now I'm booking out about 2 weeks in advance. And so I'm telling folks, I can't see you for 2 weeks. But in the meantime, you need to go ahead and order your records. Here's the link. Do your best, try to order them, and then in 2 weeks, we'll talk about it. And if you need help, then I'll help you. But I tell people to order it as quickly as possible, because if it's 2 weeks, that's 2 weeks quicker they get the records. What are other sources of records that folks might want to submit? I know one biggie that I've lately have had a lot of luck with are VA records. And that's especially useful for someone who may have, for instance, someone who's trying to change the narrative, may have a good characterization of service, but they need the narrative changed. And so in that case, this person may be eligible for many VA benefits, but maybe they're not eligible for GI Bill, or they're not eligible for something else. In those cases, what I love about VA records of late, the last few cases I've had with VA records, are they will often send them on CD-ROMs, which is very convenient, not having to scan them ourselves, which is wonderful. But also what I really like is that they are much more detailed, at least the ones I've seen lately, than the military records, and often will mention a lot of military medical providers really, they kind of phone it in sometimes, at least from what the records show. The VA doctors, and again, they do it too sometimes, but I've seen more methodical, detailed records that can be really useful. So I really am now really a fan of getting the VA records if your client is dealing with the VA.
Well, this kind of gets into the next area here in terms of how do you argue these cases. But if part of your argument is going to be current rehabilitation, then you want to start with those military records and find out what at least the military thought the problem was. But you want to have a really good talk with your client about what they can bring you about their current life. And I always give people a list. Here's a list of, after spending an hour with them, 5 to 10 things that I want from you. I want at least 3 letters of recommendation. I want to know about your work, or if you own a business, I want to know about that business. I want a copy of your web page. I want to if the issue is, for instance, alcoholism and rehabilitation, I want a letter from your spouse that talks about what a change you've made in yourself. I'm doing one right now where for a younger person, I'm getting letters from the parents. What a change, my son has made. That those are gold. Depending on the person, I want 3 years of the face pages of their taxes, just to show that they paid their taxes. Especially true for immigrants, if that's one of the issues here. That look for, I call it good guy stuff, but any place that you can find good guy stuff. And then I ask them for one picture of the family. And not, because if you say pictures of the family, then you'll get 40. One picture of the whole family, at the beach, at Disneyland, so with Mickey Mouse in the background. That's great, and I always attach that. So I want to look for, because I'm lazy, and my primary argument in these hearings is almost always current rehabilitation. I really want them to bring me in that good guy stuff. If they're in, and it's almost, gosh, so many of these cases are drug and alcohol related. I want AA meetings. I want a letter from their sponsor. I want all those things. And I'm just going to stack those up and make that part of my argument.
Sure, absolutely. And I think, Dan, that when you talk about some of the tools that you use, when you send a list to your clients, so ideas for how to give the board a better picture of who they are today, right? There was a policy guidance that came out in 2018. It's called the Wilkie Memo. Should be included in the materials when we update them after today's presentation. But really, Wilkie came at the heels of some of the liberal consideration guidance. So for veterans that experience mental health conditions and perhaps had something to do with their substance use, self-medication, or perhaps had something to do with their trauma reaction, absences or a decline in performance at work. So Wilkie is another good thing. It's not very long, right? Just a handful of pages and pretty accessible for folks to review and really help get the juices flowing in terms of getting a strong clemency type argument, right? So we need to remember, here in this small area of administrative law, we're not dealing directly with an entitlement, right? So as in 1 + 1 does not necessarily equal 2. There are no requirements to quote unquote meet, and then you're guaranteed an outcome, guaranteed an upgrade, or guaranteed a record correction. No. The boards exercise a lot of discretion, and they don't have to give any relief, any upgrade or correction. And the rates for relief have remained low, even despite the recent guidance about liberal consideration and that kind of thing. The boards are so able to justify opposite outcomes for applications that seem very similar in terms of their fact pattern. So the right approach in terms of tone and strategy, and showing somebody that seems worthy or seems to have made amends, that kind of thing. That's a really crucial component of any other types of error or impropriety arguments you might be trying to make.
Anna Marie, I know that you look these statistics up when we were getting ready for this, but yeah, remember this, that it's hardest with the Marine Corps. Next is the Navy, next is the Army, and easiest with the Air Force. That and just in terms of the way they look at these things. Let's go back to the Wilkie memo. The Wilkie memo is just a great guideline. It's what is this? They're like 7 subsections, or in any case, you can just copy those subsections, and that those can make your subsections in your brief that you file with the BCMR, and just give them the information for each one of those subsections. It makes a huge difference. So.
That's actually, I was thinking.
Oh, you're muted again, James.
Can you hear me now?
Yeah, we hear you.
Maybe a little.
Okay. Can you hear me now?
Well, we hear 3 or 4 of you.
Uh,
Can you hear me now?
Yeah.
yes.
Okay. I was going to ask Anna Maria, in your experience, it makes sense.
I'm gonna get a little sign that says no.
Sorry, James. Yeah, we had you, and then it sort of did a fade out situation. Were you asking me whether we recommend submitting the memo as an exhibit?
Well, you do it, since we can hear you talk about it.
Sure, absolutely. Yeah, and since some of the other guidance based on applications that touch the mental health issue, or the military sexual trauma issue, the boards have been showing that they at least are aware of them and understand how they're sort of supposed to evaluate the evidence. So that we're talking about Carson, Hagel, and Curta. But for the Wilkie memo, I think the boards have been slow to, really understand that favorable language and adopt it when it comes to post-service conduct. So sure, it's only a few pages. Submit the Wilkie memo itself and cite to it in your brief. If you're a footnote person or an inline citation person, that's just a matter of style. Just remember you're writing to mostly non-legal audience, so they're not JAGs. They're not attorneys, but they have varying levels of experience in reviewing applications. It looks like James has gone to chat here, so he was asking about whether we should tie the arguments directly to the memo, citing to it or not, and so that's a yes, and absolutely. The experience has been, unfortunately, for us, because of our focus on applications based on mental health, no coincidence, just because of the liberal consideration guidance. We still try to add in the clemency and Wilkie stuff, but you'll frequently see just a one-line, a throwaway line in the board's decision about post-service conduct and the fact that, yes, we considered your evidence, and they'll say that by itself, they won't consider it to be enough to be a basis for relief. But hopefully, in combination with the other evidence, talking about any changes in policy or, more enlightenment in how commanders exercise their discretion today, or perhaps more understanding and more victim-centric services when it comes to survivors of military sexual trauma.
So, Anna Maria, yeah, give us some examples of how you do that. And maybe, because I'm going to call you as soon as we get done about a military sex case.
Gotcha.
Maybe talk about that in particular, because they're now bringing up cases from years and years and years ago that they ignored.
Mm-hmm. Yes, I'm not sure if you mean their renewed focus on prosecuting offenders versus cases that they looked at before in terms of the victims perhaps acting out and receiving discharges that were, detrimental to them. But before I address that, I see another question from James about the makeup of the board, and I think that's a good point. Just to dovetail on my earlier comments, when you're writing these briefs and putting an application together, remember at the DRB, you're writing to current, usually higher level officers, so 06 and above. And I'm using, I think in the regulation it still says 5 members, but at least at the NDRB we're seeing usually a 3-member panel.
Oh, really?
If you're
Oh,
raising, I don't know where they think they can just do that, but I guess it's at least an odd number, so no ties. But so three-member panel of current active duty officers. I think at other branches they might be higher level NCOs as well, but I've only seen officers, and it's majority vote. If you raise the mental health issue, one of the members has to be somebody with a medical background, so usually a Navy doctor, right? And they are a voting member. If you're going to the board for correction, so BCMR or BCNR, it again is going to be a 3-member panel. This time they're going to be higher level DoD civilian employees. So some with veterans, some of them are veterans, but some of them aren't, right? And there's a certain amount of time that's elapsed. So they perhaps can also look back on their service and realize, nobody's perfect, and who among us, right, can say that they made 0 mistakes, and or just somebody whether they can apply the standards differently from somebody that's still in the military and perhaps has interests that are more sympathetic to, okay, is this somebody that was hurting the mission or helping the mission? Is this somebody that I would want to work with? Versus the civilians at the board for correction. Another distinction is, again, at the BCMR, BCNR, if you raise the mental health issue, they likely will get an outside opinion. So they might call it an advisory opinion. So somebody that's a psychologist or psychiatrist to do a records review and apply CURTA. A lot of the times they'll just adopt the opinion of the advisory opinion, but technically that person is not a voting member, so different from the Discharge Review Board. The biggest similarity, these folks aren't usually not attorneys. James, just reading out James's comment at his last in-person appearance before the DRB. He was just complimenting the board members with a close reading of the record and being very conversant on the issues. So really engaging with a veteran and the reasons that they ended up with the discharge they had, and the reasons that maybe they're seeking to change that. Sorry to interrupt you, Dan.
No, don't worry about it. I made three signs. So here, the first one is, James, you're on mute.
Okay, number 1.
Then the next one is, yes, I agree.
Okay.
And I'll hold these up at appropriate times. The next one is, no, that is stupid.
Well, please. Hey, that's the advantage of having multiple folks speaking and giving their opinions, right? You got to tell me when there's something that you really, you need me to fix about my approach, because I love.
Talk to me about choosing to go to the board versus do it on paper.
Sure. Yeah. First of all, you have to make sure that you are within the 15 years if you're trying to say that you have the right to a hearing, right? That only exists at the Discharge Review Board. So within 15 years of discharge. So if you're seeking relief that only the board for correction can give, just remember that. Is it more important to have that oral advocacy piece, or to go for the relief that only the higher level board can give? But there is, I sure wish James's mic could just fix itself now, just because he always has wonderful things to say about his hearings and the preparation that goes into it. For veterans that had traumatic experiences and perhaps remembered that they didn't have a lot of support from their chain of command at the time of their discharge, it can be difficult to sort of face those officers again, right? They're not the same folks, but they're stepping in their shoes, if that makes sense. And so That's something to consider in terms of re-traumatizing somebody that may be in a fragile state, or maybe has really experienced a lot of healing over time and can show the remorse and reflection and just give the missing context from their mouth directly to the people that will be deciding.
Can you hear me?
Yes, please. Oh,
Okay,
good.
great.
We spoke it into existence. Please
We
go
did.
ahead.
So we'll see how long it holds up. Yeah, that question is always a tricky one. And also another factor in it for many of our clients is finances, what they can afford to do, whether they can afford to travel for a board. I have heard through the grapevine, I haven't got the chance to do one of these yet. I have heard through the grapevine that they're doing more of these via Zoom. Is that the case from what you've seen?
Yeah, actually, Teams at the NDRB. So
Okay,
that's interesting.
great.
Yeah, more
So I
emoji
think
options.
I do think that does help our clients a lot on the finances, because that was an issue for some of my folks, particularly some of my pro bono cases. That the fund, I mean, they didn't have enough money to send for me to travel there or them. So we submitted in paper only review for that reason, which was unfortunate, but that's sometimes how it works out. But I am really excited with more of the options for the electronic presentations. I would say, if possible, though, if I was doing one of these through Teams or Zoom or one of these other electronic means, I think the ideal thing, though, would be is if I and the client were in the same room to do, so that way I can pass notes. I can all the things that you could normally do sitting at a table, you can't do as easily via Zoom. And there's always the chance you could hit the wrong button and accidentally send the text to everybody rather than just the person, just your attorney. So I do. When I get the chance next time to do one of these and do it via Zoom, what I'm going to try to do is arrange it so my client and I can be in the same physical location, just because I do think it helps. It helps to be able to, I think also for our clients, if the line of questioning is too quick, some of again, my previous in-person board experiences, what impressed me was the board members had read the everything. I was very pleasantly surprised by that. I'm used to, in other contexts, Article 138 and other contexts, of always having this feeling, are they really going to read this? In this case, it seemed like they had. That's the good news. The bad news, but it's just good to be prepared. They zeroed in immediately on the weak point of the case. They knew the case well. They knew our weak point. But I also knew our weak point. So we had arguments ready to go. But what I was impressed with was they zeroed in right on the issue. And so because of that, knowing that, being ready for it, we had a game plan of how we were going to deal with that. But I would say, to me, the ideal thing is, I'd also say, for the hearings, I would always say spend a lot of time prepping our clients. I've done it in various ways of kind of a mock hearing just to give them practice. Sometimes it's just me asking the questions they might get, or sometimes finding other people to ask them questions. But they do need practice answering on their feet. And I wouldn't call it as closely, intense as, say, cross-examination, but it can be pretty close to that. The board members, they really can zero in and ask some tough questions. And so I like to prepare my clients very thoroughly to say, okay, what's the worst thing they could ask you? Okay, let's talk about how will you respond to that. Just get and what I found is, for a lot of the clients, having talked about what's the worst thing we're most afraid of. Let's talk about that. Doing that in advance, then it makes it less scary. And again, we may get lucky. The board doesn't go there, but if they do, the client is prepared. They're ready.
For sure. And, we just briefly touched on hearings here. I know we're short on time, but also in the materials, I'd recommend a recording. I think it's a podcast. The Boston Bar Association did another, I think it was about an hour long training on discharge upgrade hearings specifically. So if that's what you're gearing up for, I certainly would recommend it. Again, not every discharge upgrade case will have a hearing component. At the Board for Correction, I think I only know of 2 or 3 examples where they granted a request for a hearing. Again, because you don't have a right to it by statute anymore after the 15 years.
Okay. Also, go ahead, Nan.
Well, I was just going to say, Anna Maria, maybe you could give us a couple examples of some winning arguments that you have in recent history, and why you think those worked. And we talked at the very beginning a little bit about the difference between making a legal argument and making an equitable argument?
Sure. Yeah, absolutely. You know, I'll share a couple here. I want to make sure that we have time for questions and that sort of thing if we want to go there. But I think you had asked for an example touching on military sexual trauma, and that's one where it can be really tough because of the culture of silence and the culture of perhaps victim blaming that that the military is trying to address now and has invested a lot of resources in developing new programs. Still not perfect, right? Still low rates of reporting, even to this day, despite the additional options that survivors may have. So if we're looking at a veteran that served in the Vietnam or Cold War era, right? They may have experienced something that we now know to be, a military sexual trauma incident during basic training or boot camp, right? At the time, it might have just been considered toughening somebody up or, preparing them for, if you can survive this, you can survive anything, right? So certainly, one challenge in making a successful military sexual trauma argument is if the veteran is not comfortable, putting that label on themselves. But that really is, what we argue is that it can give context to certain behaviors that we don't, we acknowledge that they're not in line with what we expect of a service member, right? We expect a service member to report to duty, to obey orders. But if the order is go back to work to the person that attacked you, or if going to work means, revisiting the scene of the crime, as it were, right? We can see that, what we now know as PTSD can help explain those behaviors of unauthorized absence and perhaps failing to obey orders, right? So if you have medical evidence that sort of lists those symptoms, perhaps to this day, right? Or a provider that's willing to make that connection in some sort of informal letter, right? That's evidence that could support the brief that you're going to put together following the factors in CURTA and submitting to the board, right? So minor misconduct that we can, even if, the military or the VA perhaps has characterized it as a pattern of misconduct, if they're the types of behaviors that we can connect to what we now know as mental illness, those are getting traction under the CURTA memo and the liberal consideration guidance before that.
Another practical.
Let me just say that in regards to the PTSD and sexual trauma, the New York Times magazine this last Sunday was dedicated to looking at rape, and in particular, the issue of hiding the fact that a person has been raped and why that happens, and then how it comes out later. It's very useful in the case I have right now that involves a person coming forward some 15 years after the fact and saying, the reason I engaged in criminal activity, I actually have them on a criminal appeal issue. The reason I engaged in criminal activity was because of the rape that occurred while I was in the service. So, of course, I don't have all the service records yet, but what I have, of course, there's no mention at all in the service. And so now I'm looking for instance, changes in the evals. Did the person go from having very high evals to very low evals over a 6-month period? And can I pinpoint a place in time where the rape occurred, so that to give some objective background to our subjective testimony that this occurred?
I also wanted to talk for a moment, if we could discuss for a little bit some more practical issues, particularly as far as the actual components of the paper packet that would be submitted. Normally, there, of course, is the application itself, which, again, many uninformed people think, oh, just fill out the form. But no, that's that's more the coverage of the thing, you might say. Normally, then I think about a brief, making all the arguments, and then all of our supporting documents. I think one question I always wonder about is length. And really, it falls into two categories. One is the length of my brief. And secondly, how much of the paper trail should we provide to the board? Is it possible sometimes to provide too much? I'm curious what your thoughts are on that, because my assumption is attention span is always an issue. The other thing I'm always concerned about is how do I get it past the administrative staff? Because my assumption, y'all can tell me if this is correct or not, but my assumption is the board administrative staff seem to have a lot of control of how these cases move forward. Sure. And that I think it's for very understandable reasons, they're screening these to see which ones are really worthy of the board's time or not. And so I think those that they think are really worthy, they say, hey, look at this one. I think those that they don't are in a big stack that they move through really quickly and make a summary decision on. So my concern is, how do I make sure the administrative staffer tells the board, this is a serious one, it needs to be considered? And again, that goes back to attention span. What thoughts do y'all have on that question?
Well, I'll go first, but I'm sure Anna Maria's got done many more of these and a much more intellectual approach. My favorite argument is I call it young and dumb. They call it youth and immaturity, but I think if you get over 15 pages, it's a problem. I think you want to make your contentions. That's what they call your separate sections of your brief, your contentions, very clear. Mm-hmm. That, and if your primary argument is current rehabilitation, you want to put that up front. That's your first argument. And my personal feeling is that you don't get much of anywhere with really technical arguments about some regulation or some failure to provide some kind of extra counseling that other people were getting, like an equal protection argument, stuff like that. I don't think you go anywhere with those. But I really want to hear what Anna Maria has to say, because she's winning.
Oh yes, this was a contest. At the end, everyone will vote, and I expect to get even your vote, Dan. But no, I'm joking here, and I think we're close to time, so just that'll thanks. Yeah, the sign's coming in handy. Yeah, I think I definitely agree. So the error or impropriety issues, very tough to win on because of the presumption of regularity. And that's that's terminology you'll see in the board decisions over and over. Very much their view of it is, if you had those defenses or issues to raise, you needed to have raised them back then when you were getting discharged. With all the time that's passed, we get to benefit from this consideration that if you were discharged, it must have been properly, right? So you applicant now have the burden to prove otherwise, and sort of this concept of that it wasn't a harmless error as well. So definitely the equitable arguments, clemency arguments, so those have a higher chance. Probably in no small part because the folks that are reviewing it, again, non-attorneys, they're not impressed by legal jargon or you trying to show that you know about equal protection or that sort of thing. Practical considerations, James, I agree. You need to be following up to make sure your application, all of it made it through and is being considered, at least at the BCNR. And I'd be surprised if the other boards don't have something similar. But there's the mailing address you send it to, and then there's the secure facility where they review it first to make sure that there's nothing hazardous in there, perhaps, and then from there to the people who will review it for merit, and then likely some of that flagging that you talked about. On the DD forms, there are boxes to check for supposedly emergent categories, or actually that's a VA term, not the emergent claim categories. But by statute, there are a couple of things that are supposed to receive priority consideration. You're supposed to get an expedited decision, but that's, that's a relative term, right? So is it expedited if it usually takes 2 years and it only took 9 months, right? So some examples are the certain statutory definitions of war periods, mental health cases, and military sexual trauma cases. Excuse me. But yes, I do apologize. I'm not sure if we wanted to make some wrap up comments or final comments.
Well, I have one more question before we get to that, and that is if we could talk just for a few minutes about requests for reconsideration, what appeal options there are, what do we do after the case is done? It may not have turned out the way we wanted.
For sure, yes. In the past, the boards would sometimes refuse to reopen if they don't think that you have provided, new evidence. Okay. And that always, especially with the clemency guidance, certainly you could come up with a couple more character letters, or certainly there's more medical evidence that exists now because, even if only you've continued to see that same doctor, and maybe they have a more robust basis for their opinion. So staying at the boards is what you do if there's, more any potential for new evidence, in my opinion. So reconsideration is there. But if it really is, there's nothing else that could be helpful, that's when you look to filing suit, either under the Administrative Procedures Act, or something else that'll get you in federal court.
Okay. Well, I think this is a good segue point for us to move into some time for questions and comments. So for anyone who's on, feel free to unmute yourself, and we'd love to have some conversation about this. Any questions you have, and then we can, of course, always tell stories and stuff as time permits as well. But I would love to hear any questions, comments folks have. And also, I know a few people don't have their mics, or they can unmute themselves. So feel free also to use the chat, and I can always read out your question out loud if you have one.
Yeah, questions, comments, and suggestions. So if discharge upgrade is something that you're interested in, or this session has piqued your interest, topics for further discussion, right? So discharge upgrade 2.0. One thing we didn't get to talk about are the upgrades based on sexual orientation discrimination. So don't ask, don't tell, and its predecessor policies. Certainly there are in-depth trainings and possibilities there as well. There I would just make one comment that those veterans may be harder to reach or find, versus there's no shortage of folks that are looking for a discharge upgrade based on things that are not mental health or not DAD-T related.
Well, one question I would have, and I think maybe this would be others that have this question as well. What resources are available for us if we get into one of these cases and we realize we really need more to make sense of this? Who do you recommend we reach out to if we have questions? Or also,
you. I'm going to call Anna Maria in the future, but.
Well, that's a good point. The MLTF certainly is one huge source of people you can talk to. And Kathy Gilbert, who's on the line, she answers the phones and does a million other things for the MLTF. But she herself has a lot of good thoughts. So I'll just throw that out there. I pick her brain probably more than just about anyone else, except maybe Kathy and Dan I'm pretty tied with, of who I call when I need help. But I'll say the MLTF certainly. I'm also, though, thinking about, as far as some of the more practical guides, Swords to Plowshares. I know a few years back, they had a discharge upgrade handbook, I think, that had some really good materials in it. We'll have, of course, the memo. I think the memos is maybe the most important resource right now, because they really give us some clear things we can hang our hat on when making an argument to the board. Those are some of the main. I'd also though ask for some of us, we may have more demand for our services than we can provide, and so who do you recommend is to send referrals to? Certainly, I'm going to first think about MLTF attorneys, but beyond that, are there who are some other resources, organizations that would handle these cases well if we need to do referrals?
Sure, yeah. I mean, I mentioned earlier, law clinics are out there. Certainly, they don't have a very high volume, but if there's a veterans law specific clinic, yeah, in the veterans area, that's a good referral. You know, certainly the pro bono aspect is something to consider. If you have a legal aid in your area, sometimes it's not well advertised that they do have capacity to take veterans law cases. They just have the income limitations to think about. So the income qualification sometimes is something that's an issue of, you know, even a certain level of percentage of VA disability compensation, depending on how they calculate it. They might be over income. We're here.
Neil Berman. Oh, go ahead. Sorry, Hannah.
Sorry, were you going into specific firms?
No, go ahead, and I'll come in. I didn't mean to interrupt you.
No worries. Yeah. Of course, we're here as well. The Veterans Consortium. We're nationwide. No income limitations, but we do have the focus on veterans living with mental health conditions. So, you know, we have our online intake form available. Folks fill it out, you know, with the understanding that if we're not able to take the case, we're able to send a self-help guide and resources. And the other referral information that I know of, I think, is on Source to Plowshares' website.
Yeah, I think Swords to Plowshares, they do have a list of some of the legal clinics. Specifically, though, San Francisco Bay Area veterans, they definitely have capacity for them. Swords to Plowshares, I don't think I think they're mostly focusing on Bay Area. Veterans Consortium, by the way, Neil Berman mentioned in the chat as well. And I think I may have maybe attended the same webinar that Neil did, because I was really impressed with that seminar. One thing I did learn that for the Veterans Consortium, and Anna Maria, you might clarify this if I misunderstood them, but it does seem like their screening criteria, one thing very positively is that they're willing to take cases nationwide, which is wonderful. They do tend to focus on cases that they think that they have a good chance of winning. And so they are less likely to say yes to cases, for instance, of someone who has been discharged, has a lot of subsequent criminal misconduct. Those are incredibly difficult in that kind of situation. And so at least the speaker, I remember back a few months back, said that those are the ones that they're less likely to take. And it's really a matter of triage, of wanting the resources to go to the cases they have a better chance at. But my understanding is on those that they will not take, they do send them a veterans self-help guide with some resources and whatnot. Is that a pretty fair description of it, Anna Maria?
I think so. Yeah, you may have been attending a presentation by my director, Christy Bigelow, or you know, somebody else at TVC. We like to talk about each other's programs. You know, it might have been Chesley Roberts at the Women Veterans Legal Assistance Program, or it might have been you know, someone else at our core mission, which is the Court of Appeals for Veterans Claims cases.
Mm-hmm.
But I think, you know, it's not a matter of you know, ruling out the difficult cases, right? We want to take the difficult cases when we think that they meet the guidance for liberal consideration, and there likely are challenges that the board is not seeing that it fits that mold, right? So if we're seeing patterns that the board's only granting relief for mental health cases where there's military sexual trauma or combat, right? That's not the full subset of everyone that's living with mental health conditions, right? That's connected to the military. There can be non-combat trauma, certainly first responder trauma, that kind of thing. We find that sometimes veterans have a harder time winning on their own, but with the right guidance, or, you know, with the right advocacy to point the board's direction at the right things. You know, certainly we want every veteran to get assistance, and so that's why the self-help guide is out there. But the reason that we're a pro bono program, we're trying to have a higher impact than our small staff could if we were to take all the cases in house. So if folks are interested in volunteering with us, you know, we're always training folks, and the more people that we have that we can point to as a volunteer corps, the more cases that we can accept after review the records. Thanks for the plug, Neil.
So what other questions do folks have?
Wake up. Who's actually here? We don't even see your pictures.
They don't want to live on in the recording, Dan.
No. Okay.
There's Livy.
Okay.
Livy, do you have any questions for us? Well, I am thinking, just because I'm seeing some folks on here who either are past or present GI rights counselors. I am wondering, I don't think the hotline gets a ton of calls on this, but when they do you have any suggestions for GI rights counselors who might encounter potential discharge upgrade cases? Or how would a GI rights counselor approach one of these if they on first encounter?
Well, Anna Maria laid it out earlier. So think about this. You want to know, what is the person's goal, right? Do they want to just feel better about themselves? Are they looking for VA benefits? Are they looking, for college benefits that they signed up for and lost? Are they wanting to get back in and change their reenlistment code? What's, why? That's the first question. Why are they coming to you? And then that decides, what you're going to do here. Are you going to just go to the VA and nothing else? Are you going to go for a discharge upgrade, and then to which direction, to the DRB or the BC, MR, or NR? And then you want to talk about, what's going on in their lives. And I used the term earlier, the whole person. You want to find out about the whole person.
The one thing I was thinking about in the context for GI rights counselors, I think one thing that GI rights counselors have a lot of skill in is helping to find good records, and especially good mitigation, stuff that makes a person with a troubled background look better. And so one of the suggestions I would always recommend to GI rights counselors who get a call that may end up being a discharge upgrade is, first of all, work with the client to help them get the records. Help them to either know where to do it online, or help them with the paper request, but get that records request out as quickly as possible, because that's always the holdup, always is the problem. That's the first thing. Second thing, though, is that I think an ideal situation is when a GI rights counselor can work with the client in helping to tell their story, helping them to find some good supporting letters. And then at that point, then what would be ideal when the resources and whatnot are available is to then plug them in with Veterans Consortium, or with Swords to Plowshares, or with an attorney to do the final push. I think that would be a really effective way to do it. It would be a very cost-effective way to do it for the clients. I do think, I think it is theoretically possible that a GI rights counselor, I don't know if they can, Kathy or someone else might know if you can actually represent someone in the board. I'm not sure on that. My recollection is maybe so, but.
Yes, so non-attorneys can and do provide representation.
Good.
And both at the Discharge Review Board and at the Board for Corrections.
Okay, good. So one possibility is for the GERN counselor to do that. And there are some GERN counselors, such as Kathy, I would be extremely confident in doing that. Others, I would, my own personal bias would be I'd want to make sure the person in question knows what they're doing, just as you would with an attorney as well. But I do think also another option, again, is kind of the split option, where that you start off working with the GERN counselor, building up the paper trail, doing all that legwork, and then bringing on a lawyer at the end. I think that would be another way. But the idea here is that for many of the potential clients on this work, even those who can afford to pay some in legal fees, they may not be able to afford to pay what it really will cost. And so anything at least for my clients, I'm often am when I can find a GERN counselor to work with to do a lot of the legwork. Boy, it can be a money saver for the clients and it helps me to be able to charge what I really need to charge to make a living, but also to keep my clients' costs low. So I just want to throw that out there as a possibility. Kathy, do you have any thoughts? I feel like we really, you are, have probably, except maybe for Anna Maria, I suspect you probably have done more discharge upgrade work than anyone else on this call. So Kathy, I'm curious if you have any thoughts you'd like to share or anything you'd like for us to be aware of, particularly from the MLTF end of things.
Well, gosh. One thought I have is that for discharge counselors and for attorneys who are handling cases while the member is still in, there's a really good article by Swords to Plowshares in one of the last issues of our newsletter on Watch on how to prepare for a discharge upgrade before you get out. And people talked some about that before, about gathering a record. Some other things besides just organizing existing records can be done at the point of discharge and make a real difference later in a discharge upgrade case. I also want to give a plug to the discharge upgrading manual that was produced in the last year and a half by the American Bar Association. I don't know if anybody has one handy that they can hold up. No? No. It's detailed, it's thorough, gives a lot of practical guidance on how to do a case. It's not cheap, but is worth having if you intend to do a case or to do some cases.
Excellent.
And I guess the other thing I'd say is that I'm always available to chat too about the specifics of cases or about the generalities of how you deal with these boards.
By the way, while we're on the topic of boards, this is a little bit outside the scope of this, but it is somewhat related. I'm curious for Dan, Anna Maria, or any of the others of you, if you've ever had any cases you've taken before the SEB, the Suitability Evaluation Board. This is a board that service members who are still in can go to contest, say, a GOMOR, General Officer Memorandum of Record. Have any of y'all had experience on those? Okay, shucks. I have such a case, and I was hoping that someone would have experience. But yeah, I have learned. I'm learning quite a bit about these SEBs, and they're very interesting, but they're also pretty limited by regulations and statutes of what they can do. But they can be useful in some cases to. It's basically the idea is if the record can be cleaned out before the discharge, you do it through the SEB. But if that's not possible, then you do it through BCMR. So, in fact, my understanding is if someone was in to get to BCMR, I think in some cases you would need to go to SEB first to exhaust your administrative remedies, is my understanding. Well, we have a few minutes left, so while we're waiting for any other questions, and again, we would love questions, but I will mention just in passing that this CLE presentation is organized by the Military Law Task Force, the National Lawyers Guild. We are an organization that's engaged with anti-war, anti-militarism work through a legal framework, taking our approach, our philosophy from the NLG's approach, National Lawyers Guild approach of valuing human rights as being more important than property rights. And so questioning many of the presuppositions of our society, but for the MLTF, we do this work in the context of the military and in the context of individual service members and veterans. And so that's a piece of this work as well. And we touched on this some at the beginning, and the reasons why we do this work. But I want to I thought maybe a good place to close is to come back to that, because this is an issue of justice. It is often an issue of righting wrongs and setting people's lives in order after they've been through the ringer, either through combat experiences, mistreatment, discrimination they faced. So often these issues are not resolved while the person is in the military. And so this is, for me, it's a very core part of this work of justice, is addressing these issues. I will say that in the Guild as a whole and in leftist circles generally, there's often been critique and question of why do we care about veterans? Well, for me, the issue is very, very clear, and that is that veterans are, I mean, the obvious beginning point is human rights is for everybody, including veterans. But secondly, in many cases, those who are in the military who have had difficult experiences, they are an oppressed community. And so that's the analysis, the way that I approach this work. And so I think maybe that's a good closing point for us to consider. I do think in time, particularly as we've seen also these memorandums and what a big deal they have done, I'm also wondering over time what we can do collectively to push for more such guidance, and also what we can do to be mindful of the role of Congress in the future of these boards. And so I think there's a whole other bigger policy issue beyond the practical, but to be aware of that these boards are created by statute, implemented through regulation, and so we need to be not always assume that things will be as they are right now. These things could change at any time, and we need to be mindful and ready. So, well, thank you everyone so much for being here with us today. If you have any other questions, in fact, what we'll do, I'm going to put my email address in the chat. And feel free, if you have any questions afterwards, you're always welcome to touch base with me, particularly if you have any issues with the CLE stuff. And just a reminder, if you haven't filled out the registration form, we put in the chat earlier, but it's also on the announcement for this CLE. But fill that out. And again, just a reminder, if you're an attorney seeking CLE credit, the cost is $50, and there's information in that page too about how you pay that. Everyone else is donation only, and anything you give is very much appreciated. So I want to thank everyone for being here, and especially thank Dan and Anna Maria, and also Kathy. We ended up roping her in there. So we appreciate all of you. And also one last thing, we'll have the recording for this up in a couple of days. I'm going to edit out a little bit of the audio problems we had. So hopefully it'll be a little clearer in recording, but would encourage folks to share this recording with folks. I think at least for California's bar rules, you can watch in recorded format and claim CLE credit, I believe, for 12 months from now. So if you know someone who needs CLE credit, tell them to watch the video, pay their $50, and they get the credit. So anyway, thank you so much, everyone. And I think also, Kathy, we have an upcoming CLE. Do you want to say something about that?
Well, we have a couple of upcoming CLEs. On September 13th, at the same time of day, we're going to do one on military racism and responding to that racism through military equal opportunity complaints and other forms of redress of grievance. In October, when we don't have a date yet, we're going to do a seminar on military sexual assault and sexual harassment and how to represent victims or survivors of those situations. These are part of the same CLE series that James has pretty heroically started. And we hope that y'all will be interested in attending those as well. Again, September 13th, and then a date that we don't have yet in October.
Lastly, I'll mention that we do have a little more funding left for more CLEs in the future. We have a grant that that's funding these. And so if you have an idea for a topic you'd like to present on, we're all ears. So please be in touch with us. We also, though, there's also a topic that maybe you don't want to present on, but you feel like we really need this. Please be in touch with us as well, because we're wanting to find topics that are relevant that people will find engaging. So please don't hesitate to be in touch. So, well, I think that's it for now. Thank you so much, and we'll see you maybe in September. Bye now.
Thank you. Bye.
Bye, everybody.